India's top court has spoken clearly, unanimously, and with constitutional finality. The Supreme Court today ruled that the courts cannot impose timelines on the president or governors, and that the idea of the deemed assent is completely alien to the Constitution. Drawing a very clear line between judicial review and executive authority, the court said that the governors are not rubber stamps, but neither can they sit on bills forever, and that prolonged, deliberate inaction can be examined under limited judicial review. This judgment comes after months of hearings. Remember, the court had repeatedly clarified during the hearings, we are not sitting in appeal over Tamil Nadu judgment of April 8th. The Supreme Court cited the April 8th decision where 10 Tamil Nadu bills pending for 2 to 5 years were declared, I would say in a way declared deemed assented using Article 142. Today the Constitution bench said clearly that goes beyond judicial authority. Today's judgment was in response to a rare presidential reference under Article 143 filed by President Draupadi Murmu in May after the Tamil Nadu case triggered a national debate on the power of governors. Supreme Court in its judgment made it clear the President is not bound to consult the Supreme Court every time a bill is reserved under Article 201. So what did SC say? Center-state relations, federalism and the role of bhavans. These are the issues. First, the core ruling. Judiciary cannot impose deadlines on presidents or governors. The Supreme Court said that Tamil Nadu two-judge order, which fixed the 3-month deadline, was unconstitutional. The Constitution bench led by CJI Gavai made it clear, courts can ask for action, they cannot dictate when or what that action must be. Under Articles 200 and 201, courts can nudge a governor to act but cannot tell him to grant assent or review his reasoning. This is limited accountability, not supervision. But the court is categorical, and this is important. No deadlines for the president or governor. The Tamil Nadu directions, stuck down, unconstitutional. And the strongest message, deemed assent, does not exist in the Constitution. The two-judge bench order giving deemed assent to 10 Tamil Nadu bills is invalid. The Supreme Court cannot take over the powers of the governors or the president. Yes, courts cannot question actions, but they can question deliberate inaction meant to frustrate a bill. This is where limited judicial review kicks in. While a governor cannot be made personally liable, the court said their decisions can be scrutinized, and the bench also stressed governors cannot hold bills indefinitely. Reasonable time is mandatory, but courts cannot issue strict timelines, only direct action within a reasonable period. The bench reaffirmed the governor's power, return the bill with comments, reserve it for the president, withhold assent. The discretion says the court cannot be diluted. So here's the big question tonight. Does today's ruling restore the original constitutional balance, or does it risk allowing governors to drag their feet without consequence? On this issue, I'm joined by Suresh Chandra, former Law Secretary and former Central Information Commissioner. Thank you so much, sir. So my question is the same to you. Does today's ruling restore the original constitutional balance, or does it risk allowing governors to drag their feet without consequence, sir?
Sir, I have not read the full judgment, but I will say this is a very balanced judgment wherein the thesis, antithesis has been made into synthesis. I take you back to 1970s in one of the matter when the Constitution bench has said that the political decisions, these are the political thickets, policy decisions, and the courts does not have that power to break that political thicket and interpret or substitute the wisdom of the legislature or the parliament. This judgment in SR Bombay versus Union of India, this political thicket was broken to the extent that they have said that the decision of the president, that was with respect to declaring presidential rule in a state. So the Supreme Court has said that the action has to be reasonable, and the governor's recommendations can be reviewed by the Supreme Court in a limited manner as to whether there was a sufficient material to arrive on that decision. So as on today, the field is occupied by SR Bombay versus Union of India. Now coming to the position as to whether it has been rendered into the original position. Original position of the uh, constitution is that we have the separation of power. We are rule of law society, and rule of law prevails when every wing of the state act within its own sphere. So the legislature has to do their function. They have to discharge their duties and responsibilities, and the Supreme Court or the High Courts have to interpret the Constitution. And in the course of interpretation, they cannot usurp the power of either of the wing. So I have to read the whole judgment, but I will say this is the balanced judgment wherein they have said that the Supreme Court can have a limited judicial review to the extent of
What is
seeing
that limited judicial review, sir? If you're saying it's a balanced judgment, will it have deterrence on these governors who have become very, very political, who behave like political animals?
No, sir. See, if you see under Article 200, there is the substantive part of the article, the provisions of 200. Then there is a proviso, then there is another proviso. If we go into the first proviso, there are three eventualities. The governor can give assent, the governor can withhold, and the governor may make certain suggestions. With certain suggestions, they can ask for reconsideration. Now, in this, if my interpretation is correct, or if the Supreme Court is also to some extent has indicated that, is that power of withholding is further clarified in Proviso 1 and Proviso 2. There is a different proviso for the money bills, and again, when he withholds for referring it to the president, because there are three lists. On the one list, the state has the power. On another list, president.
You know this.
Yeah.
You have to explain it for the viewers.
Yes, sir.
What is the mitigating effect of this judgment? Let me put it this way.
Sir, I will say that the Supreme Court, by answering to the queries of the president under 143, they have done the due diligence and they have really set it right. Whatever was the Tamil Nadu High Court, the Tamil Nadu Bills were said to be deemed, assent. That is alien, they have said. So to that extent, it has mitigated that the authorities, whether it is the president or whether the legislature, every authority is accountable.
Okay.
And in the accountable, they have added one thing: some reasonableness has to be there.
Okay.
So I think
I really ran short of time, but I don't know whether opinions are binding or not, whether these opinions will bind on the state governments, whether these opinions will bind on the governors. Look at like states like Tamil Nadu and West Bengal. Governors are very, very politically active, They have very strong views.
But, sir, this is when the opinion is given, there are certain legal propositions. The legal propositions are binding. These are the law of the land under Article 141 of the Constitution.
Okay.
Whatever they have said, it is not only binding on the state governments. These are also binding on the union government.
Okay. Thank you so much.
These are the law of the land under Article 141 of the
Okay.
Constitution.
Okay. Thank you so much, sir. Thank you so much, sir. Because
And
ultimately
they
this
have
was a
one last word. They have about Article 142.
okay.
So the courts cannot overreach by usurping the powers under Article 142.
Okay.
142 is for complete justice, not
Okay.
for laying down law.
Okay, thank you so much, sir. Thank you for clarifying, giving us the detail of what the judgment or the opinion that the Supreme Court had given.